The first 3 days of this conference were devoted to cooperation in the Caspian region and promoting investment and economic activity generally. We have heard from the Afghan delegation and His Excellency Minister Mastu about the importance of peace. It's difficult to invest in a country where there's war. We have heard from Mr. Kelimbetov, the chairman of the Astana International Financial Center, about the importance of free zones and regulation. Where I'm going with this is that in order to have investments, you have to have appropriate conditions and an appropriate infrastructure for investments in business. If you want to invest in a country, you want to make sure that your investment is not devalued or misappropriated. And if you want to do business in a country, you want to have a proper legal framework in case something goes wrong. We have along this panel 4 experts in the Caspian region. On the right we have Guy Blackwood QC, who is one of the top commercial barristers in London. Guy has recently represented a client against the State Oil Marketing Corporation of Iraq and won in the Supreme Court. He has also done a number of worldwide freezing orders and interim injunctions in English courts. On the left we have, immediately from me, we have Ms. Olga Sorokina, who is the managing partner of a Russian law firm, O2 Consulting. Olga has worked on a number of energy and infrastructure projects in the Caspian region and elsewhere. And immediately on the left after her, we have Dr. Irina Paliashvili, who is the president and senior counsel of Ukrainian and Washington-based law firm RULG Legal Group. Irina has likewise worked on a number of oil and gas disputes and transactions in the Caspian region. And what I propose to do now is for the participants to speak about some issues which they have faced while working on transactions and disputes in the Caspian region. And then we will try to come up with solutions or potential solutions to those issues. This is our goal. We'll start with Ms. Olga Sorokina, please.
Dear guests, welcome to our very important discussion. So why this discussion is really important and not a boring legal discussion? Because now to be really successful, it's actually it's almost impossible to be successful without being international. And to be international means to know how to cooperate with your partners, customers, investors from different countries, to know how to protect your worldwide assets, how to minimize your legal risk, how to resolve your disputes or conflicts. So, and as a result, to achieve the best possible success out of this international cooperation. So thanks, Vitaliy, to introducing me. My name is Olga Sorokina, and I'm a managing partner of a law firm specialized in mergers and acquisitions in cross-border transactions with a special focus to Great Caspian region. So out of our recent experience, we can notice that during last years, the quantity of cross-border transactions, whereas the party is one of the businesses located in Great Caspian region, is significantly increasing, which is a very good sign. And it means that the company in Great Caspian region now operate in a truly globalized world. And they are required to comply not only with a variety of different law contract provisions drafted by very creative legal teams from different countries. They need to comply with the national and international law, and what the businesses really need is to have a fair and supportive dispute resolution system to help to safeguard this growth and especially in the conditions, economical and political conditions, which are very challenging. So I strongly believe that effective mechanism of dispute resolution is vital to the future health of international cross-border transactions and trade. But okay, probably now I'm telling very obvious and very simple things, and if everyone here understands the importance of possibility of alternative dispute resolution instruments, why we are still discussing this problem and why such problems still exist. So after a brief analysis of countries and the local legislations of Great Caspian region, we came to several conclusions, and we identified a number of problems which, according to our opinion and opinion of our colleagues, are the most significant. First of all, the problem is the access to arbitration. So in the Great Caspian region, okay, my position, maybe not everyone would agree to it. So with only one exception, as Kazakhstan, all other countries are having a problem with an access to arbitration. We can take an example of Russia. Recently, Russia had arbitration reform, and now there is a licensing requirement, and all arbitration institutions need to apply to government to obtain a special license. So the idea behind this initiative was a really great idea. Actually, it has been done within an idea of de-offshorization, and Russian government was a great initiative to increase the reputation of Russia as dispute resolution, as a legal center, to transfer the center of dispute resolution from LCIA and other popular venues to Russia, to replace Russian foreign entities, which has been used by businesses by Russian entity. So, and why this licensing requirement has been introduced? Because in Russia, we had serious problems with so-called pocket courts. So most of the courts have been somehow affiliated to its founders, which created grounds for fraud, and reputation of Russia as dispute resolution center was really relatively low. So it's very difficult to conclude if the main problem has been finally resolved with this initiative, but it's evident that another problem appeared, because now in Russia we have only 5 arbitral institutions instead of more than 1,000 than we had in pre-reform years. All 5 institutions are located in Moscow. Russia is a big country, so it's a big region, and as a result we've got many businesses in Siberia, in Vladivostok, and different regions who have almost no access to arbitral institutions. So the same problem we can see in Azerbaijan with only one international arbitration institution, in Turkmenistan with the same problem. And again, the good example probably here is Kazakhstan, where we now have more than 20 arbitral institutions, very well equipped with fantastic infrastructure. So here we can use Kazakhstan as a good example as alternative dispute resolution mechanism comparing to other countries. But again, the problem with an access to arbitration is not only one problem that we identified. The second problem is the lack of trust to arbitrators, and this problem is much more difficult to deal with because, again, the most popular venues are ICC in Paris, LCIA, Stockholm Arbitration Institution, and the quantity of disputes which the parties bring to foreign out-of-region institutions is increasing again. So we do not have any positive a positive impact out of multiple reforms, including Kazakhstan. So how can we deal with the lack of trust to arbitrations, to our arbiters, and how we can again change the situation? So first of all, we would need probably to engage professional experts to promote regions as a really center of international trade and very interesting case to attract experts worldwide. But for this purpose, definitely the fees and the cost of as a remuneration for arbiters needs to be increased, because if we compare the cost of arbitration process in London and LCIA and in Moscow, for example, the difference is more than 4 or 5 times. So it's very difficult to attract really high quality experts and to create a trust if the conditions will be not such attractive. The second point, I think we need to promote the idea of local arbitration centers, because we can notice, me, for example, as a legal practitioner, when I prepared this topic, I obtained lots of information on, for example, in Kazakhstan, international arbitration centers, on again, on this Caspian arbitration center. So such institution exists, but legal practitioners have very limited access to this information. So it's really good that in such conference, especially in Davos, we can exchange information. We can provide more specific and more detailed information about possibility of alternative dispute resolution mechanism and institutions. So, and this initiative can be supported and developed again in the future. So I think in the second part of our discussion we'll be discussing more in detail what kind of solutions we can use. So maybe my colleagues will continue with identifying problems about dispute resolution mechanism.
Thank you very much, Olga. I think just one immediate comment, one of the solutions might be the denationalization of arbitration in a way. We'll look at some of the available solutions right now. Guy will explain this from the point of view of English law and English courts. Can we have the remote for the slides, please?
So I've entitled this short talk Progression and Regression because I want to analyse whether we're actually moving forward or backwards when bringing people who don't act honourably to book. And I'm going to look at concealment, contempt, evasion and execution, enforcing arbitration awards or judgments. So in my view, the common law tends to be very flexible. It is a principle-based system, unlike some civilian codes which draw more on rules. And the common law designs remedies quite quickly, whereas other civilian jurisdictions tend to take rather longer. But I wanted to ask the audience a hypothetical question before moving on. So imagine you have a train load in railway containers of fuel oil somewhere in the Caspian region. Your counterparty, who has sold you that oil, then misappropriates it. It takes the oil to a jurisdiction, a hostile jurisdiction, from which you can't retrieve it. In the interim, you find out that this is happening, so you get an injunction from the High Court in London, because your sale contract has an LCIA arbitration provision, and the other side simply ignore it. But worse still, you find out that the people who are doing this misappropriation are not even directors of your counterparty. They are running the company, but they're not listed on any register. And my question is, what do you do then? I don't know if anyone would care to venture an opinion. Do you give up? or are there remedies available? And if we can move on to the next slide, unless anyone has a view. Well, it's not so much shadow directors. Shadow directors are people who hide in the wings and in accordance with whose instructions a board normally acts. But what those people are in that situation are de facto directors. As a matter of fact, they are the directors of the company, even though they don't appear in any of the corporate documents. And this is a trick used, I say trick, it is commonplace when ultimate beneficial owners want to distance themselves as far as possible from their corporate vehicles so as to try to avoid any liability, which really ought to rest with them. And very recently, towards the end of last year, the English law has now been clarified. You can serve de facto directors out of the jurisdiction and hold them liable for contempt of court, in this case breaching an injunction. And whilst that may be somewhat anachronistic, it does focus minds, because the penalty is up to 2 years imprisonment, sequestration of assets, and a fine. I mean, you may find that the other side says, I don't like the UK, I never intend to come, I like it even less now after Brexit. But trading banks and financing banks don't like to see prison sentences on people's records. So it really does focus minds. And it is a way of, if not always, certainly frequently, sorting out situations such as this and making people behave. Another great weapon where you're looking at somebody who's not behaving honourably, what's called transactions defrauding creditors. If somebody gives away valuable assets to some related company for next to nothing, that transaction can be unwound. And I had one particular case where I acted for underwriters who had paid out for a constructive total loss of one of the big dredgers which builds islands in places like Dubai. Having paid out, the person who'd received the money then transferred the ship, the dredger, to one of its associated companies in Nigeria. It was worth about 50 million, but the price paid was €1,000. The sale to the Nigerian company, unsurprisingly, to Nigerian law and a Nigerian arbitration. And the great thing, if we could move on, Vitaliy, about this particular provision is it doesn't matter if the transaction is not subject to English law or jurisdiction. All you need is a sufficiently close connection between what was occurring and the attempt by the creditor to defraud, by the debtor to defraud his creditors. This is a very powerful provision. It's not used often enough. I think, although people say piercing the corporate veil is always an exceptional course, it is time and it is right that that particular remedy be expanded. And the reason is that SPVs are becoming more and more commonplace. You frequently find a long chain of SPVs between the operating company and the ultimate beneficial owners, where the sole purpose of all of those SPVs is again to relieve the person who should be liable from that liability. It's a means of giving a remedy which has been around since at least the 70s, but I think in light of modern business practices, it ought to be expanded. And then the next remedy, sorry, just if we could go back, Vitaliy. The next remedy that is important, that's available in common law, but again generally not in civilian jurisdictions, is a proprietary remedy. But what I mean by that is you can say this particular money that you paid is mine. I only paid it because you made a misrepresentation, and I want that money. And the great advantage of that is that you can trace it. You can require the person who received that money to say, where's it gone, and recover that money from whoever ultimately benefited from it. It is a much more beneficial remedy than simply damages, because the person to whom you are entitled to claim damages has probably dissipated all of the funds, your money. I'm not going to go into this case in great detail. It went, as Vitaliy said, all the way up to the Supreme Court. We'd had 3 different answers from 4 judges, and in the Supreme Court we scraped home 3-2. But the important point, I think, at a high level about this case is to consider intercepting funds payable under a letter of credit. You will know that they will either be issued in London or New York, or at least most of them will be, and it is now the law that they can be intercepted. In this case, it was a payment due from Crédit Agricole, the issuing bank, to the state oil marketing organization of Iraq. Surprisingly or otherwise, they weren't very keen on paying their debts. So we stepped in, we intercepted one of these payments, and the great advantage of appointing a receiver by way of equitable execution, is that he can ask, in this case Crédit Agricole, who he suspected were issuing letters of credit. Shell was buying oil in very large amounts from Iraq. You can get the receiver to write to the bank and say which funds are due under letters of credit. And the bank will comply, because the receiver is an officer of the High Court. And if it doesn't, they'll be in contempt of court, which, as we've seen, has fairly serious, or can do, consequences. Now, I probably would say this because I'm a common lawyer, is the progression part, but are things going the wrong way? And I think in some institutions they are. The DIFC courts, which, as you know, is a common law jurisdiction, to have a mechanism whereby any arbitral award could be entered as a judgment of the DIFC court, and importantly, that could then be taken onshore, so enforced in any country which was party to the Riyadh Convention, and a lot of them are. So Saudi Arabia is a good example, which is very difficult to enforce otherwise. But unfortunately, the powers that be in the Emirates have created a new judicial commission, as they call it, with 3 local judges and 2 common law judges to decide whether anything should be enforced onshore. 100% of the time it is 3-2 in favour, again surprisingly enough, of no enforcement. So much of that tribunal's attraction has been dissipated by this judicial commission. ICSID is another area where at least certain people are trying to disband the whole concept as it exists now of investment treaty arbitration and replace it with a World Investment Court, doubtless stuffed full of representatives of the various states involved. So it's difficult to see, if that concept comes to fruition, that very much will ever be found in favour of the investor who's had his investment expropriated. And the complaints that are brought against the current system, I think, are very weak. Lack of transparency, well, that could be said about any commercial arbitration, and the fact that there is a gender bias, that there aren't enough female arbitrators sitting on investment treaty disputes, which I think is probably right, because about 80% of them go only to 2 arbitrators, one who is French, one who is Swiss. Probably we know the identity of both. But it's certainly something that needs to be improved, but not a rationale for dismantling the system. So in certain areas I think we're going the wrong way, but there are options, I think particularly in the High Court, where you seek to redress wrongs created by a recalcitrant debtor.
Thank you very much, Guy. will have seen the advantages of using English courts and using London as the seat of arbitration, whether it's in the Caspian region or elsewhere. In the Caspian Arbitration Society, in our main rules, we have a provision to the effect that whichever seat you choose, you may still seek interim remedies either at the court of the seat of the arbitration or in London. This is a unique provision which you don't have in any other rules, to my knowledge, and which makes these remedies available to you if you use the rules of the Caspian Arbitration Society, regardless of whether your arbitration is seated. So I would like to invite Irina now to comment on her experience in the region.
Thank you, Vitaliy. And after Guy so brilliantly described the remedies available under English law, I would like to come back to our region. And when I talk about our region, I mean a broader Caspian Black Sea region. There is no good name for it, unfortunately. But like, for example, in International Bar Association, which is the largest organization of lawyers in the world, we called it ECA region. ECA meaning Europe, Caucasus, Asia. So our region is basically a linchpin between these three regions, Europe, Caucasus, Asia. And I think right now our region is undergoing a major renovation and becoming probably the global infrastructural center. And that's because of the One Road, One Belt Chinese project, where it's a huge transit route. And for example, we like to call ourselves the New Silk Road lawyers in this region. And of course, this process takes time. So I would say probably within 10 years, our region will be completely revamped. And with all these huge infrastructural projects taking place that cost billions and billions of dollars, it's very important that investors feel that they can seek protection in case of disputes. With whom are those disputes in most cases? With the governments. Because the investors invest in the infrastructure, they sign all kinds of deals with the governments, concessions, production sharing agreements, all kinds of other deals, and then the disputes arise with the government, the governments. The good news that in our region, most of the countries are members to either ICSID, which is Investment Protection Convention. I believe only Kyrgyzstan and Russia are not members of ICSID. Almost all the countries are members of the New York Convention, minus, I believe, Tajikistan. Turkmenistan, yeah. And of course, many of them have bilateral investment treaties. I represent Ukraine, and fortunately, Ukraine has not seen an international treaty it doesn't want to sign. It signs all international treaties and conventions. So we have a very strong web of international conventions protecting the investor. However, it turns out that it's not enough because the international investment arbitrations take a lot of time, unbelievable amount of cost, and then even if investor wins, the enforcement and collection are huge problems. The countries which are biggest abusers globally figured out a way of hiding their assets, sovereign assets. And we know who those sovereigns are against which most of the investment disputes are won. They're hiding those assets. They only keep the assets available which are under sovereign immunity. And the investors may have won a huge arbitral award, but they cannot collect. So I think this is one of the biggest challenges. No matter, how successful the investment arbitration can be, if you cannot collect, what's the point? And in this situation, I believe that we as New Silk Road lawyers need to think really hard on what we can propose as the new solutions versus the old-fashioned solutions for the investors to feel comfortable that in case they win investment disputes, they can collect against the governments. And old-fashioned arbitration institutions, of course, are there. They're extremely expensive. They're very lengthy. When international arbitration was first created and became available, it was called alternative dispute resolution. And it was created because the courts were too long, too expensive, and then, the business community was seeking for alternative dispute resolution. But I believe that currently the international arbitration is no longer alternative dispute resolution. This is a mechanism which is as long and as complicated as courts. Of course, in many countries, the court systems are transparent and fair, etc. And in our part of the world, unfortunately, it's not always true. So that's why the investors are seeking international arbitration. But what ideas we can come up with, and here when you walk the streets of Davos, you can see the signs, the posters saying that, seeking change or offering change, something like this. So what kind of change we can offer in our part of the world, in our region, that will really make investors comfortable? And I was thinking one of the idea is international convention of the countries of bigger Caspian Sea, Black Sea region, where the governments will create reserve funds and will be obliged to create those reserve funds and allocate money there. So in case they lose the international investment arbitration, the money will be paid from those reserve funds. There are all kinds of other ideas that can be discussed. And of course, it's very important to innovate in international arbitration institutions, because the old-fashioned institutions, and I'm talking now about in our countries, like international arbitrations under chambers of commerce, they are really a little bit backwards. They are behind the innovation, behind the technology. So I think such organizations or such institutions as the Caspian Arbitration Association really has a huge advantage by leading the way, by showing innovation, by coming up with initiatives that will make our region truly the global infrastructural center. Thank you.
Thank you very much, Irina. I think there are two kinds of issues that we have to address, basically, in any international arbitration and Caspian region specifically. Those are technical issues on the one hand, and we've discussed the licensing requirements in the Russian Federation and in other countries, some of the solutions which are provided by English courts. However, there's also a cultural issue. In order to resolve an issue, we need to understand what the issue is. And for that, we need to have a forum of arbitration practitioners and generally dispute resolution lawyers from along the path of the Belt and Road Initiative and Caspian region in particular, so that we know what the issues are, so that we can resolve them. In the Caspian Arbitration Society, we've revolutionized slightly how we accept arbitrators, and we accept arbitrators free of charge. Everyone is free to join when they have arbitration experience, of course. And then when we prepare our rules, we conduct online surveys in which those arbitrators and other arbitration practitioners are free to participate, so that we draft our rules not in vacuum. We actually ask people to tell us what their problems are and what they think the potential solutions could be, so that we can then implement them in a common dispute resolution mechanism, which is the Caspian Arbitration Society, and hopefully we won't be alone in this field.
Yes, I can give you a practical example of the problems with some of the market leaders at the moment. We're thinking of the ICC and ICSID. The average length of an ICSID arbitration is just under 4 years. And I have been involved myself in an arbitration since 2014. It has sat variously in London, Paris, Madrid and Athens. It's not yet finished. There will be further hearings this year and very possibly next. And the costs are eye-watering. They are larger than most middle-sized commercial disputes. So there is a need for expedition in the arbitral world.
Thank you. I think we might have time for one or maximum two questions because we are running out. So if anyone has any questions, please go ahead. Or if not,
thank you very much. If I had to ask you to give me 3 bullet points, 3 short points, what makes the Caspian Arbitration Society stand out and why people should turn to it rather than the LCIA or the LMAA or the ICC, what 3 points would you mention? What makes this stand out as a businessman's choice?
well, firstly, we are not promoting any government. So generally, arbitral institutions tend to be based in a certain jurisdiction, like the DIFC, which is intended to promote the image of Dubai as a financial center. We are not like that. We don't like to have a connection to any jurisdiction. We welcome arbitrators from all countries. That's first. Secondly, it's the way, which I already mentioned, in which we improve the arbitration rules. And third is the rules themselves. We already mentioned the availability of the very strong and effective remedies of the English jurisdiction, which won't be available to you if you use LCIA rules, but the Zurich seat, for example. And then there are a number of other issues which we are going to discuss at 6:30 tonight. We'll have a separate presentation of the Caspian Arbitration Society. So anyone is welcome.
I would say in one word, expedition. The rules are designed to resolve disputes quickly. The longer things go on, the more expensive they get. And whilst that may be tremendous for people like me, it's not tremendous for the client.
Thank you very much.